Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. So, we're all kind of disappointed that Proven Industries is wrapping up. That case is drawing to a close. But wait, there's more. All right, the first thing that we're going to have to talk about is me taking a massive L. So, let's get on with that. So, previously, I talked about how I had filed an opposition to the sealing order. And we have a response to that. The response is endorsed order directing the clerk to strike 34 non-party Ian Runkle's response in opposition to motion to seal under Local Rule 1.11. No party has moved to join non-party Ian Runkle under Rules 19 or 20 of the Federal Rules of Civil Procedure, and Ian Runkle has not properly moved to intervene under Rule 24. Nor does it appear facially that Ian Runkle, a non-party to the transactions at issue in this case, would have a basis to intervene in this action. Accordingly, the motion filed by non-party Ian Runkle is due to be stricken. Ian Runkle shall not make any new filings in this case. If any new filings are made, they will be stricken. Man, that's embarrassing for that Runkle guy. So let's talk about this one, because previously I had criticized Proven for basically throwing lawyers at a problem they should have thrown engineers at. And in this case, well, I don't think I'm wrong. I think the judge has actually made an error here, because the local rule 1.11 specifically allows for non-parties to file an objection. And I'm, a non-party. And when the judge states, well, I don't have any issue with the underlying transactions, like the defamation and the copyright infringement allegations, all of those things. Yeah, but that's not why that section allows for filing of oppositions by non-parties. The most common non-party who would take an interest in a motion to seal would be the press, and I am at least arguably the press. Anyway, so the judge does not seem pleased with my filing, and that's fine. And I have said, sometimes it's not a time to throw lawyers at it. This is one of those times, because what I could do is go ahead and file a motion to reconsider and be like, Judge, here's why you're wrong. And that would be dumb. And so I'm not going to do it, because ultimately I kind of already have everything I want, in that I already have all of the documents unredacted. And the other thing is that there's a perfectly good filing that is made by McNally's counsel. So it's not like the issue is going to go unargued. But the last thing I think that McNally's counsel needs at this point is for me to sit there and prod the judge with a stick until the judge is really angry and maybe takes it out on them, because it's a little easier to take it out on them than it is to take it out on me. So anyway, the long and short of this is my response to this is to talk about it here, but I'm not going to be poking this bear any further. We're good. And as noted, I already have everything I want. I've got the transcript. I've got all the documents. Those are all publicly available. So there's also, they have filed a motion to, when I say they, Proven Industries has filed a motion to redact the transcript, which is basically just to cut out all of the names and replace them with initials. That has also been nuked, and that is because they didn't include a memo. So the judge has said, hey, listen, you've got to comply with those rules. And you're saying, wait a minute, Runkle, is all you want to talk about just how your filing got nuked? No. No, because that would be a very short video, and that is not really on my brand. Instead, we're going to talk about how this case has just gotten even more explosive. And that is by introducing an entirely different case that is nevertheless connected. And I'm going to explain what I'm talking about. But Proven is introducing potentially, or at least there's an allegation of introducing a new word, which is perjury. So let's have a look at that, because this is gonna be spicy. So this is a new case, and for some of you who have been following this drama before I started talking about it, you will already be seeing Pacific Lock Company, aka PacLock, and going, oh, because as it turns out, PacLock has been involved in legal disputes with Proven Industries before, but this is a very brand new filing. It was filed on the 18th while I was traveling, so I've now had a chance to properly review it, and I can say that when I was reviewing it, my jaw was at least, 6 out of 10 dropped, because there's some stuff in there. So let's have a look at Proven Industries continuing to have a bad day. So this is Pacific Lock Company, aka PacLock, versus Proven Industries and Ronald Lee II. Complaint and demand for jury trial. So PacLock sues defendants Proven and Ronald Lee, alleging the following. Of course, this is allegations. This is, nothing has been proven. They can allege a lot of things in a complaint, but they seem to have better receipts than your average bear here. So let's talk about that. So Proven, at the direction of its founder and sole owner, Mr. Lee, are intentionally and blatantly deceiving the purchasing public by prominently, but falsely, advertising that the locks sold by Proven are made in the USA! They are not. Mr. Lee testified under oath as Proven's corporate representative that many of the locks sold by Proven are made in China, and that the vast majority of the lock cores, the actual locking mechanisms used in the lock, are made in China and Finland. I feel like Finland has a better reputation than China, but yeah, I say that. Now that I think about it, I can't really think of what else is manufactured in Finland. But anyway, let's keep going. I'm going to get angry comments by the Finns, and Finland is a lovely place. So before I get myself disinvited, let's keep going. This is an action against Proven and Mr. Lee by PacLock, one of Proven's competitors, seeking remedies for Proven's 1. False and deceptive advertising under the Lanham Act, and 2. Violation of the Florida Deceptive and Unfair Trade Practices Act, FDUPTA. Now, I always sort of comment here, they are missing a space. It's a minor thing, but my brain sort of latches on to typos and errors like that. So, yeah. Parties. PacLock is a California corporation with its principal place of business at California. Proven is a Florida corporation with its principal place of business at California. Mr. Lee is an individual who resides in the state of Florida. Mr. Lee is Proven's founder, president, and 100% owner, and controls and directs Proven's actions described in this complaint. So, jurisdiction and venue. They're suing in Florida. Why are they doing that? Well, because A, that's where some of the laws they're relying on are, and B, it's often a good idea to sue somebody where their money is, because it makes it easier to claim their money if you are later going for their money, which of course you are, because otherwise you wouldn't be suing them. Because lawsuits, you go after money. It's just what you do in these things. By the way, I apologize for the color balancing and so forth on my video. Yeah, there's a long story behind that, but suffice to say that it got screwed up and I'm trying to fix it. All right. So, this court possesses personal jurisdiction over Proven and Mr. Lee because they reside in Florida. Skipping on. General allegations. Proven's false Made in USA claims on its website. Proven aggressively advertises and markets to the purchasing public that its locks are made in the USA. Our locks are 100% or are made 100% in the USA! And made 100% USA and similar claims. For example, the Our Story page of its website, Proven prominently states, made in the USA! And like presumably eagle screech. And so we pride ourselves in manufacturing our products in America! Exclamation mark. By doing so, we are able to ensure more control over the development and delivery of our products to our consumers. This is funny because of reasons I know, but we should get to those reasons. Many manufactured products from other countries are made there in order to make production as cheap as possible. In addition, products manufactured overseas often utilize the cheapest materials available. Why, you guys would never do that, Proven Industries. You guys make a quality product that has never been subject to any criticism. Don't sell yourself short on purchasing a security product manufactured out of cheap materials to save a few bucks. We manufacture all of our products with the intention of keeping your expensive assets where you left them. Yeah, you'd hate to end up with a lock that can be defeated with, something only worth a couple of bucks. Yeah. Proven's website repeatedly advertises locks with the phrase "Made in the USA" or an American flag logo and the phrase "Made in the USA," examples of which are shown below. So specifications, and you can see in the bottom left corner there, "Made in the USA," American flag, and, eagle screech, fireworks, all of that. And then the other one, it's over in the bottom right. Specifications, "Made in the USA." So, and then the bottom right sort of block here, specifications, "Made in the USA with domestic alloy steel." All right. Proven's social media posts falsely claim its products are made in the USA. Proven also prominently claims that its locks are made in the USA in its social media posts. In the Proven Instagram post made on June 30th, 2025, shown below, Proven asserts that its model 2516 is made in the USA. And so there it is. This guy should be familiar. I don't think this is the same video as was in the McNally lawsuit, but it seems to be the same guy. And so, yeah, they quite prominently say "Made in the USA," and then in lowercase letters US. All right. Similarly, Proven's June 18th, 2025 Instagram post has text reading "Made in America," and the video opens with a shot of a trailer with a large American flag and the words "Made in the USA." So, yeah, they also here say "Made in America." So, yep, lots of that. Later in that same post, a close-up of a Proven lock component is showed with "Manufactured in USA," so there we see it, "Manufactured in USA." The audio on Proven's June 18th, 2025 Instagram post also promotes that its model GP Max locks uses an Alloy Sentry lock core. Now, I know a lot of the people watching this are lock nerds in a way that I am not. And by the way, I'm not using nerd as an insult here. I'm using nerd as people are really into it and know their stuff and are really keen on it. So you guys are probably way ahead of everything here, but Alloy Sentry lock core. Alloy is a Finnish company that manufactures its lock cores in Finland. Thus, the lock cores used in Proven's model GP Max are not made in America or manufactured in the USA, as Proven's Instagram post falsely asserts. Now, I should just note, Alloy does have a very good reputation in the sort of lock community. At least that's my understanding as somebody who's not really in the lock community, but Alloy tend to make better stuff. So this is not really, I don't think they made the lock cores that are at issue in the Proven Industries versus McNally issue. So, all right, carrying on here. On March 5th, 2025, Proven's Instagram post falsely proclaims that we manufacture everything in the USA, as shown in the screenshot below. So, Proven locks, made in America, built to last. When we say we manufacture everything in the USA, we mean it! Exclamation mark. Arm flexing? Proven's Instagram posts falsely claiming that its locks are made in America go back to at least January 19th, 2023, as shown in the post below. By the way, I know some people are going to be watching this and they're going to say, well, they probably are made in the USA. They just buy all the parts elsewhere and then assemble them in the USA. Well, that's not actually kosher in this circumstance. That's actually sort of a bit of a party foul, as we'll see. But if that's where you're thinking, no. So here we have Proven locks are proudly made in America! Exclamation mark. Get yours today at provenlocks.com! Exclamation mark. And then there's a picture of a lock sitting on a tree stump, which is not really the natural habitat of the lock, I don't think. Normally, locks should go on things you want to secure, and a tree stump would not be that. But a tree stump is about the level of what I would trust one of their locks with. Yeah. Proven's Instagram post falsely denying its locks are made in China. So on June 27th, 2025, Proven made the Instagram post shown below stating, China-made locks. This is totally false. We make everything here in America. And so we've got this guy, Mr. Hat, and he's there. Normally he's got sunglasses on, but no sunglasses because I guess he's inside, so he doesn't do that. But he's pointing at the camera, and you can see the caption, "This is totally false!" Exclamation mark, and then sweaty dude emoji. "We make everything here in America!" Exclamation mark. And then hashtag Proven Industries, hashtag anti-theft, hashtag safety first, hashtag ultimate protection, hashtag made in USA, hashtag lock it down, hashtag Proven Locks. All right. Despite its repeated representations, Proven does not make everything here in America. The audio for Proven's June 27th, 2025 social media post states, "I don't know where you got your information from. I don't know who your source is, but that is incorrect." And then the best part is going to be where the source is, which is, of course, where this filing goes right away. Ironically, Mr. Lee himself admitted, while testifying under oath as Proven's corporate representative, that Proven imports some of its locks and most of its lock cores from China. So I don't know who your source is. It's the company president and 100% owner. Yep, that's bad. Mr. Lee also testified that some of the lock cores used in Proven's locks come from Finland. Specifically, in his April 17th, 2025 deposition as Proven's designated corporate representative, Mr. Lee testified, "All right, so this is the question. And how about Proven Industries? Does Proven Industries import any product from outside the United States?" And then the answer is, yeah, our lock cylinders. Now, the lock cylinder is kind of an essential part because it is like the actual locking mechanism. It is the part that the key turns in and that is critical to the function of the lock. So yeah, when you're buying the lock and you're saying, well, I want a lock that is made in the USA, of all the parts you want to be made in the USA, the lock cylinder is definitely one of those. So, probably top of the list. So, deposition of Ronald Lee II in the case styled Ronald Lee II and Proven Industries versus Pacific Lock Company and Gregory B. Waugh. So, and this is, from, so not that long ago, April 17th. Case is another case entirely. And some of you were like, you've got to cover what's going on with PacLock. Well, it got even more entertaining before I actually got to that. So we're covering this one, but we'll probably also get to that one. So the cited portions of the Lee Depot are attached to this complaint as Exhibit A. So question, what percentage of the cylinders that Proven Industries uses on its product are imported from China? Answer, I'd feel comfortable around the 90% are imported. So, 90% is a lot. So question, where does Proven Industries obtain the other approximately 10% of cylinders? Answer, well, actually, I might have misspoke here. So Proven Industries, I want to say we personally, under dynamic manufacturing, import approximately 50% of our cylinders that we use. And then we have a vendor, that makes up for the other 50%. I'm saying approximately here. It might be plus or minus, but that's kind of close to where it's at. And they import from China as well. And then they're like a distributor of the cylinders that are from, I guess, Finland, and some that are made domestically. So I guess some are made in the USA, but doesn't look like many. So, carrying on, defendants' false made in the USA claim about Proven's Gus Hill USA products. In 2019, Proven and Mr. Lee were sued for patent infringement by Gus Hill Industries Incorporated, and as part of the settlement of that case, Proven purchased Gus Hill Industries Incorporated, according to Mr. Lee's deposition testimony. Proven now sells a product line that Proven calls Gus Hill USA. Despite its name, Proven imports from China most of the products that Proven advertises and sells under the Gus Hill USA name. On April 17th, Mr. Lee, as Proven's corporate representative, confirmed that Proven imports most of its Gus Hill USA products from China. If you're wondering why they didn't have Mr. Lee testify at the Proven Industries versus McNally thing, I'm kind of feeling that this might be the reason. And I'm hearing a dog wants to get in, but come on, pup, we're almost done. We'll get there shortly. So, question, does Gus Hill Industries LLC operate out of any of the addresses you gave? Answer, I mean, technically, yeah. But at what capacity? Because it's a product. It's like, that product line we don't manufacture. We maybe manufacture a couple of products, but it's more of a product we import and off our design. So it's maybe in 111, 112 for like storage. And where does Proven Industries import the Gus Hill product from? From China. You've heard our locks are made in China. We want to say that's false. Except for all the ones that are made in China. So, although Gus Hill USA products are imported from China, Proven advertises its Gus Hill USA products on the Gus Hill website as made in the USA, as shown from the following screenshot taken from the homepage of the Gus Hill USA website. So, why Gus Hill? Every year, approximately 300,000 new trailers are built in the US alone, and most of these trailers are sold with little or no security protection. Truck cargo thefts represent millions of dollars in losses for the US economy. Gus Hill has found a solution to this problem by providing our customers with the most tamper-proof lock system on the market. And right there on the left, it says, made in the USA. So, this is not going so well for Proven at this point. Now, again, all of this is allegations, but a lot of this is backed up by, like, his sworn testimony, which I feel, as receipts go, is pretty good receipts. Mr. Lee falsely claims Proven's products are manufactured in the USA. Despite his sworn deposition testimony that Proven imports locks and lock cores from China, and that other lock cores and its products are imported from Finland, Mr. Lee perjured himself to this court by claiming all of Proven's products are manufactured in the United States. Now, perjury is a big word. Perjury is a serious word. And let's see if they can back it up. Now, again, it's a complaint. They can say all sorts of things, but that's a big allegation. So, Mr. Lee's sworn declaration filed in the United States District Court for the Middle District of Florida on June 2nd, 2025, states in relevant part, all our products are manufactured in the United States using high-grade materials. We proudly emphasize our commitment to quality, integrity, and American manufacturing. Emphasis added. So, and this is from Declaration of Ronald James Lee II in support of plaintiff's emergency motion for preliminary injunction and incorporated memorandum of law filed in the case styled Proven Industries versus Trevor McNally. So it might be that going after McNally ends up blowing up in their face in a huge way. We'll see, but I am here to watch the fireworks. A copy of the Lee Declaration is attached to this complaint as Exhibit B. Defendants' false Made in USA claims are part of a long-standing pattern. Defendants' repeated false claims that all of their products are made in the USA and everything sold by Proven is manufactured in the United States are part of the long-standing practice of deceptive, false, and unfair trade practices. So basically, not only are they liars today, but they've always been liars and cheats and swindlers and so forth is the allegation. In 2020, during a business dispute with PacLock, Proven and Mr. Lee registered the domain name PacLocks.com, and that's PacLocks with a K, which PacLock is for Pacific Locks, so there's no K in Pacific. So, in bad faith, as found by the arbitration panel in the ICANN claim styled Pacific Lock Company versus Ronald Lee / Proven Industries. I will probably have to check that out as well. So, a copy of the decision in that ICANN claim is attached to this complaint as Exhibit C. We're not going to go over that in this video, but you better believe we'll probably go over it. On July 15th, 2024, Mr. Lee and Proven sued PacLock and its CEO, Gregory Waugh, in the case styled Ronald Lee II and Proven Industries versus Pacific Lock Company and Gregory B. Waugh. Now, every time I see that, I'm probably mispronouncing it, but the only thing I hear is like Warhammer 40k orcs screaming, "Whoa!" I'm probably not alone, but I am a massive nerd, so okay. So, falsely alleging, amongst other contested claims, that PacLock and Mr. Waugh tortiously interfered with Mr. Lee and Proven's advantageous business relationship with their patent agent, Peter Ganjian, by demanding that he cease representing plaintiffs in patent matters. Copy of the complaint in the Lee versus PacLock case is attached to this complaint as Exhibit D. Shortly after receiving the complaint in the Lee versus PacLock case, PacLock's counsel sent counsel for Mr. Lee and Proven the July 13, 2024 declaration of Peter Ganjian, which established the falsity of the claim that PacLock and Mr. Waugh caused Mr. Ganjian to terminate his representation. In material part, the Ganjian Declaration states, neither Mr. Waugh, Pacific Lock Company, nor anyone else ever demanded, requested, or even suggested that I cease representing Mr. Lee or Proven Industries Incorporated. The decision to terminate my representation as a patent agent of Mr. Lee or Proven Industries was entirely my own and was not in any way influenced by anyone else. Now, I'm super curious as to why he did that. And I'm wondering if it's connected to sort of the other shenaniganery that you get out of Proven Industries. But I guess we'll probably never know. But, so, a copy of this is attached as Exhibit E. Again, all of these things that we might go over in a later video, but we're going to keep this one to under like 6 hours. So we're not going to go over all of the corollary documents in this video. Despite being provided with the Ganjian Declaration and the express request of counsel for PacLock and Mr. Waugh, Mr. Lee and Proven refused to drop the tortious interference claim regarding Mr. Ganjian, requiring PacLock and Mr. Waugh to defend that frivolous claim. Deposition testimony taken in the Lee versus PacLock case established that Mr. Ganjian never served as patent agent for Proven. Just as a note, in order to have a tortious interference with a business relationship, you have to have a business relationship. Like, this guy, Proven is kind of coming off like those weird stalker types online who are like, I'm in a relationship with Taylor Swift, and Taylor Swift is like, no, and also restraining order. Yes. Rather, his patent agent services were performed at the direction and for the benefit of Dynamic Manufacturing Group, LLC, a different company owned by Mr. Lee. Such deposition testimony further established that the tortious interference claim by Mr. Lee and Proven was frivolous. You would think that Mr. Lee would know, like, who his employees or agents and so forth work for, but apparently not. Mr. Lee and Proven only dismissed their frivolous tortious interference claim against PacLock and Mr. Waugh after being served with a sanctions motion under Rule 11, Federal Rules of Civil Procedure. Moreover, Mr. Lee, who is a 3-time convicted felon, you knew that was going to be in here, has shown contempt for the judicial system. One of Mr. Lee's felony convictions was for witness tampering, and as quoted above, Mr. Lee provided a false declaration to this court in the Proven versus McNally case, in which Mr. Lee falsely claimed that all our products are manufactured in the United States. PacLock has engaged the law firm of Fee and Jeffries, PA, to represent and vindicate its interests in this case, and is obligated to pay the firm reasonable attorney's fees for that representation. This is kind of common. Lawyers don't usually work for free. They cost money, and as a general rule, the instant the money runs out, the lawyer is running out the door, right? So you might be saying, why are they mentioning that their lawyers cost money in the filing? Well, because one of the things they're going to be saying when they're getting to the put the money in the hand portion of the complaint is they want their legal fees. So all conditions precedent to the filing and maintenance of this action have been performed, have occurred, or have been excused or waived. So count 1, false advertising in violation of law. PacLock realleges and incorporates by reference the allegations in everything above. And they go on to say, Proven statements that its products, including its Gus Hill USA products, are made in the USA, made in America, that Proven makes everything here in America, and that we manufacture everything here in the USA, collectively called the false Made in USA claims, are all false or misleading statements of fact about the geographic origin of Proven's products. Proven's false Made in USA claims deceived or have the tendency to deceive a substantial segment of persons exposed to those claims. I.e., there might be people who buy these products specifically because of the whole Made in the USA thing. They're like, I want to support American manufacturing and American jobs, and isn't it great that we've got this company that's not doing the thing where they outsource all of their manufacturing to China and other places because, we need to bring those jobs back here. And, oh, wait, yeah. Now, clearly Proven thinks that these claims are valuable because otherwise they wouldn't be putting them all on their, on all of their advertising, right? They think that it's bringing customers in. So that may bite them in the butt. Or other places that are equally or more tender. So Proven's false Made in USA claims are material and likely to influence the purchasing decisions of its potential customers. I think this is fairly obvious, right? People prefer Made in America products. I mean, even here in Canada, now there's a big asterisk on this because the whole trade dispute aspect, but when you're looking for a quality product, I find that, Made in the USA is a better indication of quality than Made in China. Now, the trade dispute thing is its own headache, and we're going to get too political. I'm going to move on from that. But, yeah. And similarly, well, I guess we'll wade right back into the trade dispute stuff. You've got a whole bunch of people right now who are like, here in Canada saying, oh, this product is made in Canada, or, etc. And if that's not true, then customers would be upset, right? So, carrying on here, Proven caused its false Made in USA claims to enter interstate commerce through the Proven website and its social media postings, i.e., just about everything is interstate commerce nowadays, but a web page covers more than one state, right? Mr. Lee is Proven's founder, president, and sole owner, controls and directs the activities of Proven, including its false Made in the USA claims. As such, Mr. Lee is jointly and severally liable with Proven for those claims. Joint and several liability means essentially that, let's say the court says, okay, you guys are liable for, $1 million, and that is going to be divided up like 75% for Proven and 25% for Mr. Lee, or however they decide to do it. Joint and several liability means that the people who are owed the money can pursue that against either side or both sides, however they want to do it. So if Mr. Lee has all the money, they can go after him for the entire sum and then make him sort that out. So, carrying on. PacLock, as a competitor of Proven, has been and is likely to continue to be injured through a loss of sales by Proven's false Made in the USA claims, i.e., PacLock might be losing out on customers who choose Proven instead of PacLock because they go, well, Proven is made in the USA. So, yeah. Proven's blatant and ongoing false Made in USA claims, especially when properly viewed as part of a pattern of abusive and unfair practices by Mr. Lee and Proven, make this an exceptional case, entitling PacLock to an award of its reasonable attorney's fees pursuant to the law. Now, I don't know if they'll get it, but it's worth asking for, and I think they have a better claim than most that Proven is kind of a bad actor. It's not just like, oh, well, this is their first time getting sued and whatever. No. They've been, there's all sorts of chaos here. PacLock will likely prevail on the merits of its false advertising claim because Proven's false Made in the USA claims are literally false. And Mr. Lee, testifying in its capacity as Proven's designated corporate representative, admitted that many of Proven's products and components of Proven's products are imported from China and Finland. I actually am really curious to see Proven's defense on this one, because it's going to be very hard to mount a defense against this issue when you are under oath. Like, is your defense going to be that our president and 100% owner was lying under oath? I don't think so. So we'll have to see how that goes. So are literally false, and Mr. Lee, testifying in his capacity as Proven's designated corporate representative, admitted that many of Proven's products and components of Proven's products are imported from China and Finland. PacLock is suffering and will continue to suffer irreparable harm as a result of Proven's continuing false Made in the USA claims. When you see irreparable harm like this, you know that where they're getting to is, we want an injunction. That language just tells you injunction is coming up ahead. And what is an injunction? Well, PacLock wants the court to tell Proven Industries, you can't say you are made in the USA anymore. You have to cut all of that out from your advertising. Knock it off. So we'll see. That's always a harder sell, but they may get it. The loss of customers and goodwill as a result of Proven's continuing false Made in the USA claims is not able to be compensated by it should be award money damages alone. It should be of money damages alone. Yeah. The injuries to PacLock, if Proven's false Made in the USA claims are not enjoined, outweigh the injury to Proven if Proven is enjoined from continuing to make its false USA or Made in the USA claims, because Proven has no legal right to continue making those false claims. It's not really a First Amendment issue here. It's not like they're being barred from expressing their opinion. This is actually they're stating what they claim to be a fact, and doing so is illegal because there's false advertising laws and so forth. So, yeah. All right. Enjoining Proven from continuing to make its false Made in the USA claims will serve the public interest by protecting the public from Proven's false claims. One of the reasons why you have country of origin designations is for protection of the public, right? So that the public knows what they're getting and where they're getting it from. So now the reason why they're saying, serve the public interest is that these are sort of the elements of the injunction test. They're kind of going through those and saying, Here's why you should give us an injunction. We're going to see a later filing asking for an injunction, I suspect, on an interim basis. And they'll have a better claim for an interim injunction than most because they've got the under oath, issues there. We may also see a motion for summary judgment in favor of PacLock. We'll see that, and we'll cover it when we get to it. But I strongly suspect that's coming. All right. And a motion for summary judgment or judgment on the pleadings would be basically just, there is no way that they can defend this, so give us what we want. So wherefore PacLock respectfully requests that this court, A, enter judgment in its favor and jointly and severally against defendants. So that's Proven and Mr. Lee. Preliminarily and permanently enjoin defendants from making any false or deceptive claims regarding the geographic source of any products that they advertise or sell. C, order that defendants publish corrective advertising proportionate to their false Made in the USA claims. Now, given that it looks like they've been stamping their Made in the USA claims on everything, that would be a lot of corrective advertising. And are they going to have to put like an Instagram video out going, you said, or we said that it was false that our products are made in China? Well, it is true. They are made in China, or at least the critical elements of them are made in China, if they're not made in Finland. But not here. Somewhere else. Somewhere far, far away. And award to PacLock and against Proven and Mr. Lee, 1, the amount of Proven's profits, 2, 3 times the amount of PacLock's damages caused by defendants' false Made in the USA claims, which will be hard to prove, but that's what courts do. 3, the cost of this action. And 4, PacLock's reasonable attorney's fees. And grant to PacLock all other relief that this court deems appropriate. And then count 2, deceptive and unfair trade practices in violation of law. Now, this lawsuit actually doesn't go through like the usual 1 through 12 or something things. They keep it to a couple of issues, which I like. So they reallege and incorporate by reference everything they've alleged above. And Chapter 86 of the Code of Federal Regulations provides, it is an unfair or deceptive act or practice within the meaning of Section 5.1 or 5A1 of the Federal Trade Commission Act and more statute codes to label any product as made in the United States unless the final assembly or processing of the product occurs in the United States. And you might say, well, great. All they have to do is just the final assembly, putting the two pieces together, right? Wrong. It keeps going. All significant processing that goes into the product occurs in the United States, and all or virtually all ingredients or components of the product are made and sourced in the United States. So when it says made in the United States, it's gotta actually have a lot to it. You can't just take part A made in China and part B made in Finland and attach the two together and be like, now it's made in the United States. No, not how it works. So guidance provided by the United States Federal Trade Commission, the FTC, states, for a product to be called made in the USA or claimed to be of domestic origin without qualifications or limits on the claim, the product must be all or virtually all made in the US. All or virtually all means that the final assembly or processing of the product occurs in the United States. All significant processing that goes into the product occurs in the United States, and all or virtually all ingredients or components of the product are made and sourced in the United States. That is, the product should contain no or negligible foreign content. Now, negligible, could vary, right? I've got, here's a, sort of an example of a product here. I've got a product here that is a hot sauce, and it is made in the USA. I grabbed the right one. Now, the ingredients on this, they've got a whole bunch of things, and starts off with onion, Anaheim, ginger, garlic, etc. But the last ingredient is nutmeg. And so I guess if the nutmeg for instance, came from, I don't know who makes nutmeg. Let's say Ecuador, even though I don't know if Ecuador is actually a manufacturer of nutmeg, but we'll pretend that they are for the purposes of this. If that's where the nutmeg came from, they would probably get a pass, because I'm guessing that there is very little nutmeg in there, but just some, right? So, but it can't be that like the onions and the Anaheim peppers and so forth are not made in the USA, because then that would be in violation of the rules. So, carrying on. Proven false made in the USA claims constitute unfair or deceptive acts or practices within the meaning of Section 5A1 of the Federal Trade Commission Act. Proven false made in the USA claims also violate the FTC standards for unqualified made in the USA claims. Now, unqualified, you could probably get away with something that says like assembled in the USA, because that's a qualified thing, right? It doesn't say it was made in the USA, it says assembled in the USA. If you wanted to be safer, and I'm not a products attorney, there's better people if you're looking for actual like legal advice on the topic instead of commentary. But if you're actually running the risk of getting sued for something, hire a lawyer for this who sort of specializes or practices directly in that area. But if you said something like assembled in the USA from parts manufactured in China, you'd be much better off and much safer for avoiding any sort of claims that you were lying to your customers. Proven false made in the USA claims are deceptive and unfair trade practices that defendants made in the conduct of trade and commerce. Obviously, they're selling these locks. Proven false made in the USA claims constitute deceptive and unfair trade practices in violation of Florida's Deceptive and Unfair Trade Practices Act, FDUPTA. That you can tell that law was not named with an acronym in mind. Some laws, you get like the Patriot Act and so forth, and where you're like, okay, they had a plan for that. No, this in Canada we've got the Can Spam Act and so forth. FDUPTA, they did not have any of that planning going on. PacLock has suffered and will continue to suffer actual damages as a result of proven false made in the USA claims and resulting violations of FDUPTA. PacLock is likely to prevail on the merits of its claim against defendant for the violations of FDUPTA because proven false made in the USA claims are literally false, and Mr. Lee, as in not false by implication, they are directly false, and Mr. Lee, testifying in his capacity as Proven's designated corporate representative, admitted that many of Proven's products and components of Proven's products are imported from China and Finland. Wherefore, PacLock respectfully requests this court A. enter judgment in its favor and jointly and severally against defendants. B. Preliminarily and permanently enjoin defendants from making any false or deceptive claims regarding the geographic source of any products that they advertise or sell, or engaging in other deceptive or unfair trade practices. C. Order that defendants publish corrective advertising proportionate to their false made in the USA claims. D. Award to PacLock and against Proven and Mr. Lee PacLock's damages caused by the deceptive and unfair trade practices, the cost of this action, and reasonable attorney fees, and all other relief that this court deems appropriate. That's something you always ask for, because you don't want the court to be like, well, I had an idea for something additional that I would give you, but you didn't ask for it. You're like, court, if you're willing to give me anything else, if it's a puppy or whatever, I will take it. So, and they want a jury trial on all claims, so triable. All right. So, I find this to be really interesting because people were saying, hey, you have to cover the issues that they've had in the past with PacLock. And I was like, well, I got to look into that. And then we see that PacLock files a new claim. And not only do they file a new claim, but it's a new claim that is directly connected to the one I was previously covering, because they allege that there was perjury committed in the case of Proven Industries versus Trevor McNally. Now, that's a really bad place to be if you happen to be Proven Industries. I feel like Proven Industries is in a bit of soup here. And I couldn't be happier for them because, frankly, they seem like they deserve it. They seem like lovely people who deserve all the litigation. And we're going to keep covering it. There's more to cover here. I was like, it's sad that Proven Industries is doing the smart thing and getting out of this lawsuit. Turns out they didn't do it fast enough. They should have done it before the alleged perjury, not afterwards, because now they have basically they've shown their soft underbelly to PacLock, and PacLock is like, oh yes, I will totally tear that out and throw it onto the snow because, yeah. So, if you were sad because there wasn't much left to cover, you know I was. Turns out we were wrong. So I will keep you posted as to sort of the last throes of the Proven Industries versus Trevor McNally, because we'll have to see what the court orders on that one finally as to the sealing or redaction or so forth. I will also follow up with this one because this looks fun. Anyway, thank you guys for watching. I hope you found this to be interesting or educational. I also want to thank my Patreon supporters. There's a link to the Patreon in the description below. At the $50 level, Bottle Shock and Oz, Canada's National Firearms Association, the Canadian Coalition for Firearms Rights, the Canadian Shooting Sports Association, PJ's Forever, Angela Skelton, Cielo, Kyle Fox, Nether Portal 3, Purple Dragonair, and Shay B. Thank you as well to my $10 or $20 supporters, Mark, Lindsay Metcalf, Larry Kalniak, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, and Marvin CZ, as well as the $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this armed you with knowledge. See you next time.